Welcome back to Landlord Pass in 3 p.m. BC. I'm Amanda. You've screened your tenants well. Modules 5 and 6 gave you the tools to filter applications and make solid decisions. Now comes the step that decides whether your tenancy is defensible or not, the tenancy agreement. A weak agreement, or worse, no agreement at all, can wipe out your ability to enforce rent, keep deposits, or even prove what was actually agreed to. I've seen landlords spend thousands in dispute resolution fighting over terms that a clean signed RTB1 would have settled in 30 seconds. Module 7 is about building agreements that actually hold up. We're using the official RTB1 form, following strict timing rules, and creating a file so clear that an RTB adjudicator doesn't have to guess what happened. Here's the operational risk most landlords underestimate. Verbal agreements are legally valid in BC, but they're operationally disastrous. When rent, utilities, pets, guests, or notice periods get disputed, the RTB relies on written evidence. If you don't have it, you're stuck in a he said, she said situation. And guess what happens then? The adjudicator often sides with the tenant because you, the landlord, were the one who should have documented the deal. A weak agreement looks like this. The tenant moves in before the agreement is even signed. You use custom terms that contradict the RTA. You use a vacate clause to reset the lease, hoping no one notices it's not legally valid. You skip the RTB 27 move-in inspection, so when the deposit dispute comes, you can't prove the unit's original condition. You forget to deliver the signed copy within 21 days, and then you're in breach yourself. Each of those mistakes costs money. The safest strategy is to design the file so the evidence is obvious and self-proving. Jimmy's comment is direct. If you're negotiating at an RTB hearing about whether the rent was actually $2,400 or $2,300, you've already lost. A signed agreement ends that conversation before it starts. Module 7 is built around one core principle. Use the official RTB1 form as your foundation. The RTB1 is designed by the BC government. It includes all the required standard terms: rent, deposits, utilities, services, notice periods, and it's built for enforceability. You can add reasonable additional terms, but anything that contradicts the RTA is automatically void, even if both people sign it. Here's what you can do. 1. Use RTB1. Every tenancy needs it. Fill in every field properly: landlord name, tenant name, property address, rent amount, deposit amounts, which utilities are included, move-in date. 2. Add a short addendum for property-specific rules. Keep it to 1 page maximum. Smoking, insurance requirements, quiet hours, reasonable guest limits, things specific to your property. Don't duplicate what's already in RTB1. 3. Know your tenancy type. Month-to-month renews automatically and ends only with proper notice for legal reasons. Fixed term has a stated end date, but in BC, it usually converts to month-to-month at the end unless a narrow, legally valid vacate clause applies. 4. Understand vacate clauses. This is where landlords get into trouble. Vacate clauses are not a general end of lease, tenant must move out tool. They're only allowed in narrow situations: landlord or family member occupation, purchaser occupancy, or certain sublease contexts. If you use a vacate clause when there's no legal grounds and the stated use doesn't materialize, a former tenant can claim compensation of up to 12 months' rent. That's the financial exposure. So my advice, unless you're genuinely moving in yourself or the property is being purchased, skip the vacate clause. Use a regular month-to-month. Here are the failure points. Module 7 is designed to help you avoid: Number 1. Moving the tenant in before the agreement is signed. This is the number 1 operational mistake. Once they have keys and possession, your leverage disappears and disputes start immediately. Fix: no signature, no keys. This is a hard rule. Number 2. Including prohibited or unconscionable terms. Clauses that contradict the RTA are void even if signed. Unconscionable clauses, ones that are grossly unfair or oppressive, also fail and can damage your credibility at a hearing. The safe move: Default to RTB1 and keep addenda short and reasonable. Number 3. Misusing vacate clauses. I mentioned this already, but it bears repeating. If you include a vacate clause and then don't follow through with the stated reason, you're exposing yourself to a 12-month rent compensation claim. It's not worth it. Number 4. Missing the 21-day delivery deadline. You must give the tenant a copy of the signed agreement within 21 days. Best practice, deliver it the same day you sign. Keep proof. Number 5. Skipping RTB 27 condition inspections. Without a move-in baseline, deposit claims become impossible to prove. Use RTB 27 and take time-stamped photos. It protects both of you. Here's the execution system from Module 7 that creates a file you can be confident in. Before you ever open the door, draft the agreement using RTB1. Schedule a 30 to 45-minute walkthrough with the tenant. Explain rent, deposits, entry rules, repairs, notice basics. This builds understanding and reduces later disputes. Review your addendum together. Keep it short and specific. Remove anything that contradicts the RTA or feels oppressive. If there's a vacate clause, be absolutely certain it meets the legal test. On signing day, all tenants who are 19 or older must sign and date. If there's a vacate clause, make sure all required sections are completed and initialed. Deliver the tenant's signed copy immediately. Get written confirmation that they received it. Collect deposits right then. Only release the keys after signatures are complete. Within 7 days, complete the RTB 27 move-in condition inspection together. Take date-stamped photos of major areas. Both parties initial the RTB 27 to confirm agreement on condition. Within 21 days, confirm that the tenant has the signed agreement. Optional. Use RTB 51 if you want to establish email delivery for future notices. Both parties sign this. File storage. Keep everything together. RTB 1 plus delivery proof plus RTB 27 plus photos plus addendum plus RTB 51. Store digitally with a secure backup. This folder becomes your evidence in any future dispute. BC made important changes to the Residential Tenancy Act, effective June 18, 2025. Here's what changed. Landlord purchaser use notices. Now 3 months. If you're serving notice for landlord occupancy or purchaser occupancy, the notice period is now 3 months. Use the official RTB portal to generate the notice. Tenants have 21 days to dispute after receiving the notice. Deposit interest for 2025, 0.95%. Deposits earn interest. For 2025, it's 0.95% annually. Calculate and pay it before returning deposits or deducting for damage. This isn't optional. Dispute deadline, 21 days. When a tenant disputes something, they have 21 days to apply. Track these deadlines carefully. Late fees, keep them reasonable. Late rent fees must be reasonable and explicitly written in the agreement. Confirm current caps and specify the exact fee in your RTB1. A few specific things, Module 7 flags. Can I ban all overnight guests? No. A blanket guest ban is risky and may be treated as unconscionable. Use reasonable limits instead. No guests staying more than X consecutive days without written consent. Can I require the tenant to have insurance? Yes. Require tenant liability, contents insurance, and request proof. This is enforceable and reasonable. Can I charge a $50 late fee? Late fees must be reasonable. Common references in BC cite caps around $25 per occurrence. Confirm current limits and ensure the fee is explicit in writing. Can I make repairs the tenant's responsibility? No. Major repairs and maintaining habitability are landlord responsibilities. Clauses shifting major repair duties to tenants are void. What if I forget to deliver a copy within 21 days? It's a compliance breach. The tenant can seek dispute resolution to force you to follow the law. Best practice, deliver same day and keep proof. You've now learned how to use the RTB1 form correctly and avoid prohibited terms. Execute the agreement with proper timing and delivery. Complete move-in inspections that protect both parties. Build a file that can defend you in any RTB dispute. Module 7 is about creating the legal foundation. In Module 8, we'll cover deposits, how to handle them properly, when you can deduct, how to calculate interest, and how to avoid deposit disputes that can cost you thousands. When you're ready, join me in Module 8, Deposits in BC.